To see it, yes.
Okay, very good. So as Bill said, I'm Gerald Askew. I've been involved in intellectual property in one way or another for around about 20 years. I was originally an engineer, going back to 1989. Moved into patent practice originally as a patent agent, and then ultimately as a patent attorney. And so I've got a lot of experience with it. And so today I'm going to be talking to you a little bit about the various forms of intellectual property, and what the nature of those forms of intellectual property is, what they'll do for you, and some of the risks, things like that. So generally, I'm going to be speaking to you today about patents, trademarks, copyrights, a little bit about trade secrets and trade dress. So when we think about intellectual property, or when we think about patents, rather, what we're typically talking about is inventions, right? Apparatuses, compositions of matter, items of manufacture, different things that require some sort of inventive step. These various forms of intellectual property exist on the spectrum between what we call natural rights and prosecutorial rights. Natural rights is it belongs to you because you thought of it. Prosecutorial rights is it only belongs to you if you take certain legal steps to protect it. Patents are entirely prosecutorial. There's no natural right to an invention. Just because you invented it doesn't make it yours. You have to take legal steps to protect it, not the least of which is filing a patent application and going through the examination process, at the end of which you hopefully will receive a patent. If everything goes well, it is an adversarial process. It's entirely possible that you can file and not receive a patent. But when you receive that patent, it gives you certain rights. Those rights are to prevent others from making, using, selling, offering to sell, importing, inducing others to infringe that which is covered by the claims of the patent. It doesn't actually give you the right to practice the invention yourself. We don't patent things to ensure that we have the right to practice them. We patent them to make sure that others can't take advantage of the investment that we've made in the invention. So there's essentially four permutations. You can have something that you can patent, and you can practice yourself, and something you can patent but you can't practice yourself, something you can't patent and you can practice, and something that you can't patent and you can't practice. The example I like to use here is the wheel with the tire. If somebody invents the wheel in a world where there's no wheels and there's no tires, and they file their patent application, goes through examination and the issues, and they have the right to exclude everybody from making, using, or selling the wheel. And they put it out there into the world, and somebody else looks at it and says, oh, that's great, but it rides really rough, needs an air-filled rubber donut, and they invent the tire, right? So the tire would meet the criteria of patentability over and above the wheel, and so they would file their own patent application in this world where there's no wheels and no tires. And they would file their own patent application and they get examined, and it's patentable over and above the wheel, and so they would receive the patent on the tire, which would ensure that they could exclude others from making, using, or selling the tire, including the guy that invented the wheel, but they couldn't necessarily use it themselves, because inherently to use the tire, you have to use the wheel. And so there's a circumstance where you can have an improvement over an underlying technology that allows you to preclude others from taking advantage of that improvement if you get a patent on it. But you're not actually going to be able to use it yourself, because inherently for you to use that improvement, you have to use the underlying technology, which may or may not still be patented. Which leads us to two separate questions. Can you patent something and can you practice it? And they're not exactly the same question. And generally speaking, patents at some level are always divided up into genera and species, right? The genera is, in that example, the wheel. Right, the species is the wheel with a tire. A species of the wheel with a tire is a wheel with a air-filled rubber tire. Species of the wheel with air-filled rubber tire is the one with a tread on it. There's a constant, ongoing improvement that takes place, and it's often those improvements that are patentable. Let's see here. Types of patents. Normally, when we think about a patent, often we think about a regular U.S. non-provisional utility type patent, which is the ordinary sort of invention. The machine, the item of manufacture, the composition of matter, the process, procedure, those things that are inventive in that way. The term of these patents is typically measured from, or is measured from, the time of filing, and it's 20 years from that filing date until it expires, with the expectation that from filing to issuance should be about 3 years, with an effective enforceable life of about 17 years. Design patents are a little different. Design patents cover the non-functional ornamental appearance of an item of manufacture. They don't cover any of the function, basically the way something looks. I'll use my little coffee cup here as an example. It does have a design patent on it, and it basically covers the ornamental appearance. So it's got, certain relief and certain shape and certain handle on it, and so that's what's covered by a design patent. The term of those is about 15 years from grant, if filed after 5/13 of 15. Plant patents, I don't deal with these very often, but basically they cover asexually reproduced plants, and they have to have some distinguishing characteristic. You may have heard of a provisional patent application. A provisional patent application is a patent that we file that never actually issues, never gives you the right to exclude anybody from doing anything, but what it does do is it gets you a filing date. And if you file a non-provisional, regular U.S. non-provisional utility patent application within 1 year of that priority date, then the non-provisional is treated as if it was filed on the date of the provisional. So essentially, a provisional is a lightweight way to get into, an inexpensive way to get into having a filing date, so that what happens subsequent to that filing date no longer matters to patentability. And gives you some time, perhaps to evaluate patentability, perhaps to find out whether there's a market for what it is you're patenting. It gives you a year, basically, to explore that before committing to a full regular patent application. Also in the United States, we have different types of continuation applications. Applications that we can file that are related to the parent application in one way or another, and are treated as if they're filed on the date of the parent application to varying extents. So divisional is typically a previously unelected version of the invention that was in the parent application. A continuation is typically a different set of claims directed towards what was in the original application. And something that's uniquely American is the continuation in part patent application, which allows us to add new material, but only the material that was in the parent application is entitled to the parent application's filing date. So not everything is patentable, right? We can't repatent the wheel, actually. In order to be patentable, something has to be new, useful, and non-obvious, right? Novelty is usually a pretty easy threshold to meet. It's different than that which came before. Useful is also a very low bar. It has to do something, or it has to accomplish some purpose. Obviousness is a much tougher test. In order to be patentable, something has to be non-obvious. And basically what that means is, would the person of ordinary skill in the art with which the invention is concerned have known to combine the elements of the invention the way that you combine them to get the results that you got, given the teachings of the prior art at the time that the invention was filed? Now, you'll notice that that was a very long stated test for what is obvious or what is not obvious, and so inherently it's somewhat subjective. And it ends up being what we argue with the Patent Office about all the time. Also, in order to be patentable, we have to explain to the world how to do it. We don't actually have to physically reduce to practice. We don't have to provide an example, with the exception of certain classes. But generally speaking, we have to describe it in our patent application in such a way that the person of ordinary skill in the art can then go forward and practice that invention once the patent expires. And so all of this stuff has to be included in a patent application, all that description that enables that sort of use. Now, whether or not something is considered to be novel or new or non-obvious is based on what is in the prior art prior to the filing date of the application. And what is prior art? Well, basically the prior art is anything that was ever published, used publicly, offered for sale, or patented, or filed in a previously filed patent application, that is, prior to the applicant's filing date. So a lot of times what happens is people go out there and they look around and say, I've never seen my better mousetrap, you know, at Walmart or wherever. And so I think it's definitely new. I've never seen it. But sometimes what's not realized is that for every patent application that's filed, uh, um, they publish at 18 months whether or not they ever issue. And approximately 10 times as many patent applications are filed as what ultimately issue. So that if we look at the 12 million patents or 12.5 million patents, nearly 13, that are currently in the patent database, there's actually 120 or 130 million documents that are going to be considered to determine whether or not your invention is new or not obvious.
Can we move to slide 8, please, and catch up? Slides are not matching up.
Oh, okay. Yeah, that's interesting. I've got two different displays here. Since I'm using this presentation software, it's got two different slides. So yeah, thank you. Yeah, so again, because the doctrine of obviousness doesn't result in a bright line as to whether or not something ought to be considered to be patentable, there are certain things that we look to determine whether or not it ought to be considered to be patentable or not in terms of obviousness. So typically combining prior art elements using known methods with predictable results, those things are considered obvious. Yeah, I'm not going to read this list to you, but basically what it amounts to is there's certain acceptable arguments, right? For example, if there's an unexpected result, that is an argument for non-obviousness. An example I like to use is if you take a microwave and a radio and you put them in the same case, and then you go down to Best Buy and you look around, you see that there's no combination microwave FM radios. And so you think that your invention is new and non-obvious. Even though nobody might have done that and sold that product at Best Buy, it may be considered obvious if the radio makes music and the microwave heats food, right? Those two things would be known to do that, notwithstanding the fact that nobody had ever stuck them in the same case before. What if the food tastes musical? What if the music sounds hot from a combination of the microwave and the radio? That would be an unexpected result in an argument for non-obviousness, right? So there's several of these acceptable arguments. Meets a long-standing unmet need. The prior art teaches the way. There's rapid adoption into practice. Long felt unmet need is a big one. Everybody's been trying to figure out how to make their food taste musical, and you figured it out. That would be an argument for non-obviousness. Now, when we think about what is properly the subject material of patents, there are certain things that are statutory and there are certain things that are not. And then there's some of these in between ones, which the courts sort of figure out as they go. So, you know, compositions of matter, items of manufacture, machines, chemical formulas. Again, these all have to rise to the level of non-obviousness. They can't be just routine variations of things that exist. But any of these things that are listed potentially can be patentable. Let's see here. The things that are not considered to be patentable by statute are things that are essentially abstract, right? Things that can be done in the head, things that are sort of laws of nature rather than inventions. And so math formulas, algorithms, scientific principles, natural substances. Now, the use of a natural substance might be patentable, the use itself, but the natural substance might not. Software implementing an abstract idea. This brings us to a question about business methods, which is a relatively recent development. Actually, originally, the laws dealing with business methods or the adjudication of questions of business methods goes back to the late 90s, but essentially the way that this has developed is business methods themselves are not categorically excluded. However, there typically has to be, particularly when it involves an abstract idea, there has to be what they call something more, right? So in a case called Alice Corp, software implementation of escrow is not patentable merely because it's being performed on a computer, and because essentially it's an implementation of an abstract idea. Right. So when we have an invention like that involves something that is abstract, but it has some sort of construct around it, right? There's a machine or there's software that's doing something with that. Then we look for what we call something extra, right? That embodies the inventive concept. Now, if this sounds like a vague criteria, it's because it is a vague criteria. As a matter of fact, the most recent opinions that deal with it that I'm aware of really push back on the Supreme Court to try to resolve some of this because, as Chief Judge Moore of the Federal Circuit said, as the nation's lone patent court, we're at a loss how to uniformly apply a test like this, right? As a matter of fact, the most recent case, not to get too far afield, had to do with, I think it was Dana, had a patent that dealt with axles, and they were calculating resonance frequencies for shafts within the axle, and then the axle was doing something to deal with those resonant frequencies. And so, you know, it kind of went back and forth in the courts as to whether or not it was patentable because it was implementing something that essentially could be done in a person's head, and then it was taking that calculation and reacting to it. And so the test that was given as to whether that was something extra was hard enough to determine whether or not the invention qualified, that even the Federal Circuit really struggled with it. Now, when we look at a patent itself, and we look at the process of filing and prosecuting a patent, there's a couple of things that you will notice. If you pick up any given patent, you'll see that it is divided up into parts, right? The first page is basically bibliography information. Has you know, the title, it has some search history, it has information about the inventors and who owns it, who filed for it. Then there's a series of drawings. Now, remembering that the point to a patent is to not only give exclusive rights to the holder of the patent regarding what is in the claims, but it's also there so that when it expires, you know, the person of ordinary skill in the art can then practice it. The assumption is that the person of ordinary skill in the art brings a lot of knowledge to the table. So when we look at the second part, there's a series of drawings. You'll notice some things about these drawings. If you pick up any given patent, you'll notice that those drawings are a lot more like cartoons than they are like production drawings. Typically, they don't have any dimensions. Typically, they don't have any material specifications. They don't have tolerances. They don't have thread pitches. They don't have any of the things that the person of ordinary skill in the art would already know. They just have the information that regards what it is that's new and different about the invention. Then there's a section which we call the specification, which is basically a description of what is the invention, what does it pertain to, what makes your invention different from the prior art. Then there is a long, weird language section that is a detailed description, and basically it is a legal description of the invention. And so typically it'll say things like, you know, part number 105, frangibly connected along dividing line 7, you know, and it's basically this really laborious, verbose description of the invention to make sure that we have enabled the person of ordinary skill in the art to practice the invention. Now, all this is fine and good, but what actually determines the scope of our right to tell somebody else you can't do this are the claims at the end. And those are a series of short sentences that say something like, I claim the apparatus for doing something comprising, which is a magic word meaning having at least these things. And then it's just a recitation of a series of elements. Element A, element B, element C. Now, the issue is that when we file a patent application that has a set of claims like that, we think we know what we're entitled to because we think we know what's in the prior art. But because it's an adversarial proceeding, the examiners can go out there and do his or her own search. And they're gonna make a determination as to whether or not that invention is new and non-obvious over that prior art. And so because we don't know exactly what we're entitled to, the way we deal with that is we have a succession of a series of successively nearer claims. And so there'll be like claim 2, it'll say, claim 2, I claim the apparatus of claim 1, further comprising element D. Claim 3, element E, claim 4, element F, et cetera, so that when the examiner goes out there and finds something that has A, B, and C, and renders our first claim invalid over that prior art, then maybe we can fall back on claim 2, which further requires that that thing have element D in it in order to anticipate our invention. Excuse me. Now, when we're prosecuting a patent due to issuance, it's not uncommon that we go through a series of rejections, right? As the inventor tries to, or as the examiner rather, tries to determine whether or not we're entitled to that invention because it's new, useful, and non-obvious. And so during prosecution, the patent attorney's job is to try to overcome whatever rejections are given. Now, part of the way that we might overcome, like I say, is changing which claims we focus on, but it might also be amending the claims or making arguments. We cannot add any material to the application after it's filed, which means that it's very important when you file a patent application that it have everything that it needs to survive examination in the first place, right? So that it has all of the different ways that we might think of to practice the invention. The process itself, when we file, the first thing that happens is a whole lot of nothing. Basically, it goes into a big pile. There's like 45,000 patent examiners, and they deal with 1.5 million documents a day. The statistics a little old, it might be different now, but generally speaking, they're ended up to here. And so for about a year and a half, not much is going to happen. At about a year and a half, the patent, one thing that's going to happen exactly a year and a half is the patent's going to publish. And typically around that time, we start the examination process. There's usually a series of rejections. Like I say, the first one being non-final, typically an anticipation rejection. Hey, your invention's not new. And then typically a final office action, which is typically an obviousness rejection. Hey, your invention might be new, but it's not sufficiently different from that which came before. Now, with the patent office, final means final unless, of course, you have money, in which case they'll play as long as you want to pay. But beyond the first and second office actions, typically it starts to get fairly expensive. We have the right to make amendments. For the first office action, basically the examiner has to consider the amendments. After the final office action, they'll only enter it if they agree. And to go further, you have to file RCs, request for continued examination, appeals, or some other way of proceeding. It is very much a pay-to-play game. Even after it issues, you have to pay maintenance fees at 3.5, 7.5, 11 years to keep it active. Let's see here. Oops, I think I skipped ahead. No, we're in the right place. Okay, with regards to other people's patents, unfortunately, we don't teach a lot about intellectual property in undergraduate technical programs or science programs or even creative programs. And so people sometimes have the perception that if I just don't ever file a patent application, I don't have to worry about this stuff. When in fact, if you're going to be designing things or you're going to be creating things, you have to be concerned about other people's intellectual property, including their patents. Basically, to infringe a patent, you infringe the patent by making, using, selling, offering, sell, importing, or inducing others to do the same, that which is covered by the claims of the patent. Now, it's okay if you can design around so that you're not actually performing the steps or have the elements of the claims. And it's okay if you take a license from somebody who has a patent. There are certain defenses to patent infringement. understand that there is typically, the burden is on the infringer to show that these defenses apply. Every US patent that issues is presumed to be valid on issuance. It is a rebuttable presumption, but the burden of the rebuttal is on the potential infringer. Let's see here. When we try to determine whether or not you're able to patent something, or whether or not you're able to practice something without infringing a third party, basically what we do is we conduct searches, right? So a clearance search, a non-infringement, a patentability, I don't have it listed here, a patentability search and opinion is a search and opinion that tries to determine, in view of the prior art at the time that the invention is filed, whether or not something is likely to be considered to be patentable in view of the patent office, in terms of its novelty and non-obvious over the prior art that is found. A patentability search and opinion does not address the question of whether or not you can practice the invention, which, as I noted earlier, is not the same thing. And so in order to determine whether or not you're able to practice a given invention without infringing a third party, you need a clearance search and opinion. Much bigger search and opinion, because not only are we looking for, say, the tire, we're looking for the wheel, the spokes, the bearings, anything that you have to practice in order to practice that invention. Sometimes if we've been accused of infringement, we might look at whether or not we're actually infringing a patent, or we might even try to invalidate that patent by producing prior art that existed that was not considered during the examination. Again, the burden is fairly high, the burden of proof is fairly high, and so it's something that is better to avoid infringing in the first place than try to show that you're not infringing after you've been accused of doing so. Now, a patent is such that if somebody infringes a patent, nobody's going to come arrest that person. It is up to the patent holder to enforce that right, which, among other things, means that you need to mark your device or your apparatus or your invention, if possible, that it's either patent pending or that it's patented, so that the potential infringer has notice that they would be infringing by duplicating that device or whatever element that is claimed. So part of the responsibility of enforcing the patent falls back on the patent holder. Licensing can be an opportunity for patent holders. It's a way to perhaps gain market share or sell into market share that you don't have by allowing others to practice the invention for either a royalty or by virtue of assignment of the patent. Again, in order to enforce, typically the first step in an enforcement situation is a cease and desist letter, the sort of letter that we send off that says, hey, look, you're infringing this patent, you need to stop doing what you're doing. And then ultimately being willing to litigate in order to enforce that right. There are damages available, potential injunction against ongoing infringement. And then there is a limit to how far back you can go. Damages typically only for 6 years previous to filing suit. And particularly if you know about the infringement, you can't just sit on your rights, wait 10 years, and then sue the person, try to obtain all the profit that they made during the time that they sold it. You would lose your ability to sue based on your inaction. It's called laches.
There's a question in chat. Is there a website to check if something is being infringed?
Not necessarily. There is the possibility that you can mark your device and have, and this applies typically like a device or an item of manufacture that has a lot of moving parts, a lot of different things that could be patentable. In which case, the patent holder or the person that owns that right can list those patents on a web page and then just refer to the web page on the device itself. That's a virtual marking, and so if you look at a device and it has that website, you can go there and see what patents apply. But the determination of whether or not you're actually infringing any given patent is a legal determination and requires considerable research and analysis. So no, I mean, you know, I used to tell people that would come into my office, don't bother searching yourself because searching is difficult. We use sneaky broad terms to describe elements so that we encompass a lot of things, and often they are not terms that you wouldn't think of to look for in a word type search. That being said, Google Patents is fairly intuitive. It will produce relative results, but I also tell people try to refrain from drawing a conclusion, because unless you understand patents thoroughly and how they work, often you cannot tell just by looking at the patent whether or not you have an issue with it. Quite often they disclose things that aren't necessarily covered by the claims. Moving on to copyright. So we talked about patents. Patents were entirely prosecutorial rights in the sense that there's no natural right to an invention. Copyrights are entirely natural rights in the sense that copyright just springs into existence when you put something expressive in fixed tangible form. It covers certain things. Typically, it doesn't protect ideas or facts, but only the expression of those ideas or facts. So you can have one company that makes movies about Star Trek and another company that makes movies about Star Wars. The underlying idea is essentially the same. It's a soap opera in space, but the expression of the idea is entirely different. And so that does not violate copyright, right? So again, it might be sculpture, art, it might be poetry, it can be basically anything that has expression. Even code, even computer code and its arrangement has a certain amount of expression. So computer codes can sometimes fall both into patentability and into copyright protection. Copyright protects the right to reproduce, to display the work, to perform the work. Excuse me. To distribute, market, sell, prepare adaptations and derivative works, and to authorize anybody else to do the same. When we think about a derivative work, we're thinking about perhaps like a book, and then somebody wants to make a movie from that book. The movie would be a derivative work. Interestingly, the movie might require a license from the copyright holder of the book, but once the movie is created, there is a new copyright that springs into existence with respect to the movie. And so the person that filmed the movie would own the copyright on the movie. Again,
There's a
copyrights
question
arise
about
automatically.
drawings. Pardon me for interrupting you. You know, if someone has a drawing that's been shared, copied by many people, is that in the public domain, or what is there any restrictions on that?
No, unless the person has placed it into the public domain. The mere fact that it's been copied by many people just means that many people are guilty of infringing the copyright. As a matter of fact, there's a lot of confusion with respect to plagiarism versus copyright. They are not the same thing. With plagiarism, attribution helps to eliminate that, although it's not necessarily determinative. In copyright, attribution has nothing to do with it. As a matter of fact, I like to call YouTube copyright infringement tube, because there's so much ongoing copyright infringement where people seem to believe that just by saying that I didn't, this is not mine, that sort of absolves them of copyright infringement. That is not true. As a matter of fact, that's basically just admitting the copyright infringement. Now, on the other hand, people can and do place things into the public domain by disclaiming their copyright rights or by virtue of the public commons or shared commons, I think it's called. And basically, essentially, it's a license to anybody, right? And you have to be a little careful about Creative Commons because you need to look under the Creative Commons license what version of the license they're using, with respect to how you're going to be using it, because that's not a universal license for all purposes necessarily. Sometimes it is, sometimes it's not. And you need to make sure that you understand it when you use something that's like that.
We've got a question about WIPO, WIPO, and PCT. That's beyond me. I don't know what those stand for.
Okay. PCT is not something I was going to really cover today. But basically, the World Intellectual Property Organization is the Patent Cooperation Treaty is what PCT stands for, is a type of patent application that we file that gives us a priority date in most of the countries in the world. There's a 30-month pendency from its original priority date. A PCT application could claim priority to another application. But 30 months pendency is measured from the initial application, during which time there's some additional examination, and at the end of which, under the PCT treaty, you can nationalize in the various countries, and they'll basically all treat that as if it was filed in their country and on that date, the date of the priority date of the PCT application. There's a lot of rules with respect to additional bites at the apple in terms of examination. And so it's not something I necessarily can get into today. The only thing I will say about PCT is that PCT applications make a lot of sense if you're going to be broadly protecting an invention around the world. For inventions where you're going to protect it, say in the United States and a handful of other countries, it tends to be a little more economic to file directly under the Paris Convention, which is a much older treaty. That allows you to directly claim priority to a U.S. filed application and allows the other countries to do the same. And it tends to be a little more economic. PCT applications, there's other reasons to do that, but that's kind of beyond the scope of the discussion today. So turning back to copyright, there are some reasons, even though copyright arises automatically, there are some good reasons to go ahead and register a copyrighted work with the Copyright Office, not least of which is, depending on the federal circuit in which you're in, it affects when you can sue and under what conditions. And so it also creates a legal presumption of validity, and it's a fairly low threshold. It's not adversarial. There's not much of an examination process. And it is actually one of the few legal services I recommend to people that if you can read and follow instructions, go to the Copyright Office website and you can go ahead and register it yourself. There's not a lot of ways to do it wrong necessarily. Copyright ownership. Copyrights essentially are owned by the author, but there are exceptions. If it's work made by an employee pertaining to the work that they're hired to perform, then it's a work for hire. If it's work commissioned, or if the copyright's been assigned or otherwise sold, in a co-author situation, either may use, but they have to share their profit. In a joint work, basically it's two or more authors that tend to merge their contributions into one creative whole, like an encyclopedia or whatever. And again, if a creator of a derivative work has permission or a license from the creator of the original work, then the derivative work is subject to copyright by the creator of the derivative work. Now, copyright term, the length of enforceability is fairly complicated. As a matter of fact, if anybody ever asks me about a given work, I have to break out the rules and kind of run the traps and run it through and figure it out myself. It's not something that you can just look at it, take one glance and know. With sort of the exception that if it was published before 1929, it's in the public domain, but be careful about that because a lot of things like, say, the Bible, which is in the public domain, translations and interpretations of the Bible aren't necessarily in the public domain. There were several changes in law in terms of what term would apply and under what conditions. And so basically you need to make sure that you understand when it was registered or when it was published, when it was created, And what happened thereafter, during certain periods of time, it was necessary for the Circle C to be used, notification to be given rather. And then subsequent to 1989, that doesn't really apply anymore. With regards to assignment and licensure of a copyright, if all rights are transferred for an indefinite duration, that's typically considered an assignment. If less than all rights are transferred or it's for a definite duration, that's typically considered a license. Licenses can be exclusive. In other words, only you can use this, or non-exclusive. I'm going to let you use this, but I'll let other people use it as well. Excuse me. Let's see here. End user licenses can be valid if the user who disagrees with the terms can return the product for a refund. Again, it's helpful to give notice with regards to copyright enforcement. It's helpful to use the Circle C. It's not required, but it does make it easier to obtain damages and precludes the innocent infringer defense, which is an attenuated defense anyway. It also makes it possible to obtain certain relief, injunction, restraining order, monetary damages, and attorney fees, depending on the circumstances. Again, this sort of enforcement usually starts with a cease and desist letter. Let's see, depending on the federal circuit, you must either file prior to suing or have the certificate of registration in your hands. The sort of damages that you can get might be actual damages plus profits, or it may be statutory damages, which are forfeiture and destruction. There is criminal copyright infringement. Typically, when there's intentional infringement with full knowledge for commercial advantage or private financial gain, can result in prison as well as significant monetary damages. Now, defenses to copyright infringement, these are somewhat fraught with peril. I always tell people, make sure that if you think that you're engaging in fair use of a copyright, make sure that you review that with somebody who has expertise in it. Independent creation, when we think about patent infringement is relatively strict. Doesn't matter whether I knew that somebody had a patent on it or not. With copyright infringement, although infringement is strict with respect to copying, it does actually require copying. So if somehow somebody that writes a poem to their significant other and they put it in their dresser drawer, they never publish it, and you happen to write the same exact poem and you put it out there, and your friend comes along and says, hey, you've infringed my copyright. He actually could not have, because if he stuck that in his dresser drawer and you had no access to it, then there's no way that you copied it. So independent creation is a defense, as is authorized use, which may be by permission or by license, can even be applied. Fair use is probably the most risky. Transformative purpose, there's no bright line with respect to this, but typically things having to do with teaching, research, scholarship, teaching, criticism, commentary, parody, journalism, just be careful with this. It does have to have a transformative purpose, and there's really no bright line with what is transformative and what is not. You are allowed to make archive copies. You can make de minimis use, but again, be very careful with this. De minimis use, if a work is famous, may not be a defense. So I have a dream, right? As a quotation, if it was done without this if it wasn't for fair use, would probably not also be de minimis because it is such a famous statement. There is a statute of limitations, 3 years from discovery. If it's ongoing, you can bring suit within 3 years of any given infringement, but you can only collect back 3 years. Public domain, we talked about what's in the public domain before. We talked about the difference between plagiarism and infringement before. Works by an officer or employee of U.S. government, of the U.S. government, are not copyrightable, and they're automatically in the public domain. just make sure that you're sure that it is work by an officer or employee in their capacity as an officer or employee of the U.S. government. But actually, the reuse of works by the U.S. government is fairly common. As a matter of fact, when I take coursework towards my PE license, which is currently expired, the companies that teach those continuing education in professional engineering, they use governmental materials quite extensively. States are generally immune to copyright infringement claims. Federal and local governments, not necessarily. Some states waive first sale doctrine. You know, if you buy a CD, you turn around and sell that same CD or DVD or whatever, or Blu-ray. You can do that because it was a legitimate copy. The copyright pertaining to that basically was exhausted on sale. So I can resell. There are some exceptions having to do with art. Be a little careful about art. But generally speaking, if I have purchased a copy of something, I can do with that copy as I see fit. I can't copy that copy, but I can do with the actual copy itself as I see fit. Now, turning to trademarks, you remember I said that intellectual property tends to be, it exists on a spectrum between natural rights and prosecutorial rights. Natural rights, it belongs to you because you thought of it. Prosecutorial rights, it only belongs to you if you take legal steps to protect it. Trademarks are sort of a mishmash. They're sort of halfway in between. They are part prosecutorial in the sense of federal registration to obtain a nationwide right to exclude others from using our trademark. That is a prosecutorial process. You have to file and go through an examination process the same way that you do with patents. And they're part natural rights. Under common law, trademark rights arise when you begin to use a mark in commerce to identify the source of goods and services. That being said, common law trademark rights are typically much more restricted than federal trademark rights in the sense of geographic coverage, at least geographic coverage. And so with respect to trademarks, you know, remember in the patent world, we could have something we could practice and something we could patent, and they weren't necessarily the same thing. In the trademark world, there's three permutations. If you can patent, or I'm sorry, if you can register something as a trademark legitimately, which actually remains an open question for a period of time, but if you can legitimately register it, you can use it. There's really not a situation where you can register it, but you can't use it. But if you can't register it, whether or not you can use it depends on why you can't register it. If there's a previous federal trademark that you can't register in view of, then you also cannot use it, right? If there's a previous common law trademark that has a priority date that goes back earlier than your filing date for your federal trademark, or earlier than your earliest use date on which you're relying, then whether or not you can still use the trademark depends on the conditions under which that common law trademark right arose. Particularly if it's located in, you know, say it's on the West Coast and you're only using it in Indiana, Michigan, and Ohio, and it's just a common law trademark right, it's not federally registered, then you may still be able to use it. The purpose of trademark is to identify the source of goods and services, so that when we buy a Coca-Cola, for example, we drink that Coca-Cola, we can rely on the reputation of the Coca-Cola company. It probably doesn't have arsenic in it. The reason that we can do that is because only Coca-Cola is allowed to call that beverage Coca-Cola. Other people can make beverages that are similar to Coca-Cola, they just can't call it Coca-Cola. So when I buy a set of Goodyear tires, I go 100 miles an hour on them. I'm pretty sure they're not made of Play-Doh. They're not going to come flying apart. Play-Doh is its own trademark. Isn't that funny? And so I'm relying on the reputation of that company in buying that product, which I can only do because I'm confident that if it says Goodyear on it, it's from Goodyear. And that's the purpose of trademarks. Now, a trademark itself can be anything, right? We think about words, slogans, logos, graphics, jingles, things like that, but it can be almost anything. It can be the shape of a Coca-Cola bottle. It can be the green color of a John Deere tractor. It can be the smell of Stetson cologne. All of these things can operate as trademarks. Even things like characters in movies can operate as a trademark. If I go see a film and it's got Luke Skywalker in it, then I know that film either came from or was licensed by Lucasfilms, because that is a trademark for Lucasfilms. So there's a little crossover there in these different forms of intellectual property sometimes. Now, another thing with regards to trademarks is we cannot register or enforce trademarks that are merely descriptive, right? So if I'm going to sell Gerald Askew's three-legged stools, then we as a society are not going to tell somebody else whose name is Gerald Askew, who's selling three-legged stools, that he can't say, my name is Gerald Askew, I'm selling three-legged stools. Initially, that trademark would not be registrable, because it is a mere description of who I am and what I'm selling. In the same way, I cannot register a trademark for the term milk and tell everybody else that they have to stop calling milk milk, right? Because milk is just a descriptive term for what the product is. And so, at least initially, trademarks that are descriptive are not registrable. Now, typically they don't hire attorneys for easy questions, and so there's often a spectrum between those descriptive terms and other terms that are called distinctive or fanciful, right? So distinctive trademark terms are typically things like words that are made up out of thin air, right? So think about Google or Verizon or these different terms that we see around us that are conjured out of thin air, so that when we see that term on a product or with an association with a service, that we know that that's what it's being used as, is as a trademark. The other way that trademarks tend to be distinctive is if we take a normal term and we apply it in an inapplicable fashion, right? So think about Amazon for online sales of products, right? Amazon doesn't say anything about the products themselves. Think about Apple for computers. There's nothing Apple-ish about an Apple computer. I cannot squeeze an Apple computer and get apple juice, right? So that it would be a distinctive term. The appearance of an apple on a computer indicates to me that, oh, that's a trademark. It's being used as a trademark. And so the distinctiveness tends to make it more registrable and more enforceable. And then there's all these sort of in-between ones that we have to try to determine. Now, over the course of time, even a trademark that is descriptive can become registrable. So when we think about McDonald's hamburgers, that is a descriptive trademark, right? The guy's name was McDonald. He was selling hamburgers. Now, I've been using this example for years, and somebody pulled me aside and said, well, actually, it was Ray Kroc that was selling hamburgers. Okay, but the point remains that it would normally be considered a descriptive trademark because it's merely a description of a product and a person. Over the course of time, trademarks that are not registrable because they're descriptive can become registrable by virtue of acquired distinctiveness, or the fact that there's lots of advertising and lots of awareness that McDonald's hamburgers is something more than just some guy named McDonald selling hamburgers. But it takes time to establish that acquired distinctiveness. And so it may not be registrable from the beginning if you're in a situation where you're trying to choose a mark. If you're choosing a mark that is generally descriptive, then it's going to be sort of an uphill battle to show that people have begun to recognize it for something more. Whether or not a trademark is registrable in view of a prior mark depends on its likelihood of confusion with that prior mark, right? So if I'm going to sell, well, likelihood of confusion breaks down into how similar are the goods and services and how similar are the trademarks, and actually a bunch of subsidiary tests that we don't actually apply unless it's unclear from those two main tests: how similar are the goods and services and how similar are the trademarks. So if I'm going to sell tires and I'm going to sell them as McDonald tires, I might be able to do that because the average consumer of burgers is not likely to be confused that the burger joint suddenly started selling tires. the goods and services are sufficiently different that there's not a likelihood of confusion. However, if I was going to put up the golden arches and have Ronald McTire guy stand out there, chances are that I might have a problem, notwithstanding the fact that they're different goods and services, because I have raised the similarity of the mark so high that the dissimilarity of the goods and services no longer matters. Now, again, these are usually not bright line issues, right? We get into the questions of, well, I'm going to sell soup mixes as McNuggies, you know, is that too close to McDonald's? And they're sort of similar goods and services, but you don't buy soup mixes at a fast food restaurant. So sometimes there's not really a bright line as to whether or not you can register in view of a prior mark. But again, those are the tests that are applied. Also, to register a federal trademark, you must show that you are using it in interstate commerce in order to be registrable. You must show that you're the first user with respect to a class of goods. Now, the trademark office does recognize that when you are preparing to go into business, you may not have actually used a given trademark yet. And so there is the possibility to file what's called a bona fide intent to use type trademark application, what we call a 1B, in which case you go through the examination process as if you are going to use it. And then at the end of that process, when it allows, you have X amount of time to show that you've gotten it into use before it will actually register. Typically that's 6 months. It's extendable for another 6 months. Just by paying a small fee, you can extend it out to a total of 3 years. But after the first year, you have to show that there's a reason why you're not using it. Initial registration is for 10 years. You must file a statement at the 5 to 6 year mark showing that you're still in use. And then thereafter, every 10 years, measured from the registration date. Also, if you've been using it continuously after registration for 5 years, you might be able to file a petition for incontestability, which basically closes the door on any legal challenges with respect to likelihood of confusion. Now, the trademark registration process, again, we put together an application. We choose our class of goods and services. We choose what it is we're going to use it with respect to. We provide an example of the trademark itself, which may be, by the way, a standard form, which means the words irrespective of how they're presented, or it may be special form, which means the words plus a given graphic or a graphic by itself, which is called special form. And then we provide that information. If it's in use, we provide an example of the use of the trademark, which often means it appears on the goods, appears on the packaging, appears on advertisements. Web pages can work to show that you're using a trademark, but there are certain things that must be on that trademark, on that web page. Specifically, the trademark itself must appear. That's a given. A picture or description of the goods or description of the services must appear closely associated with the trademark. And there must be the ability to make the purchase via the trademark or via the web page, rather. It's not enough to have a web page that shows the goods and services, shows the trademark, and then just gives a phone number to call if you're interested. That will not work to show use with regards to a trademark. Again, it's an adversarial process. The USPTO considers whether or not it's in use. They basically consider its likelihood of confusion with a prior mark, any given prior mark. They consider whether it's generic or descriptive. If you survive that process, it's published for a short period of time for the public to comment, during which time others may object to that registration by way of an opposition, which is a fairly expensive procedure. Even after it registers, others may petition the USPTO for cancellation of the mark based on likelihood of confusion or for other reasons up to 5 years after it's been registered. Again, at 5 years, you can file a petition for incontestability and foreclose the likelihood of confusion basis. But there's anytime it becomes generic or abandoned or misused or whatever, that can go on indefinitely. Once it's on the principal register, the infringers are presumed by the courts to be willful infringers. They're considered to have constructive notice, makes available triple damages plus attorney's fees. Basically, registration makes it easier to enforce the trademark. We've already kind of gone through the difference between inherently distinctive trademarks. There's a couple examples here. Again, Google, Pepsi, Reebok, these are words that are conjured out of thin air, or common words that are used. Camel for cigarettes is a good example of a arbitrary, unexpected manner. There's the ones that are in between. Coppertone sun lotion. It's sort of descriptive of what it does, but not entirely. And then things that are directly descriptive. Trademarks are all assumed abandoned after 3 years of non-use. That being said, be careful about using a trademark just because it's not being maintained at the trademark office. That does not mean that necessarily the trademark has been abandoned under common law. You can only use the Circle R with respect to a patent after you have your trademark in your hand, your trademark certificate in your hand. To use Circle R without federal registration is fraud. TM, on the other hand, has no actual legal significance. And so when you're using a trademark, whether or not it's been registered and you believe that you have trademark rights in it, you can and should start using TM. Now, the tests for whether or not trademark is infringed are very similar to, but not identical to, the tests that we use for whether or not it's registrable. And there's several factors. And some of these actually relate back to the subsidiary considerations when we're looking at registrability. But trademark infringement rather, is its own analysis as to whether or not somebody's actually infringing a trademark. Again, the more similar the marks, the greater the chance that that is a appropriate legal conclusion. Trademark remedies, you can get a temporary restraining order. You must show likelihood of success on the merits. You can get an injunction plus damages based on profit or loss. You can get destruction of the items or labels with the mark. If it's intentional, trademark infringement may result in punitive or triple damages, fines and attorney's fees. Typically, however, that has to be a fairly exceptional case. There is the possibility of the innocent infringer defense, where there's no possibility of consumer confusion. Often that's geographically limited with no damages. Let's see here, fair use. Fair use with respect to trademarks, again, is somewhat perilous. The same that fair use with respect to copyrights is somewhat perilous. However, typically, if a trademark appears in such a way that I'm not using it to advertise or promote my own goods or services, then typically that may be considered fair use. So, for example, if a trademark, say that I'm filming a screenplay and one of my characters is holding a Coca-Cola bottle, chances are I don't have an issue. There is a different threshold with respect to famous marks called dilution. I couldn't actually use Coca-Cola to sell tires because Coca-Cola is so famous that the quality of my tires may affect the perception of the Coca-Cola brand, notwithstanding a lack of actual confusion as to who I am. But there is, again, fair use with respect to trademarks. Another one that we get into from time to time is comparison. For example, if you go into Walgreens, you'll find Waldrill right next to the Benadryl. Waldrill is not being sold as Benadryl. It's an invitation to compare. As a matter of fact, there's usually an invitation directly on the bottle that says compare to the ingredients in Benadryl. That is a fair use because it's making it clear that Waldrill is not Benadryl, but it's inviting a comparison between the two. News reporting, commentary, non-commercial use. Repair or reconditioning is okay as long as the words repaired, used, or reconditioned appear. The seminal case has to do with reconditioning spark plugs. They were Champion spark plugs. The company was reconditioning them, selling them as reconditioned spark plugs. And that was found to be okay because it was clear that they weren't being sold by Champion, that they were being sold as reconditioned Champion spark plugs. Now, trade secrecy is a different kind of intellectual property, and it's basically an intellectual property that's not really registered anywhere. It is affected or is created by keeping a item of information secret. The threshold of trade secrecy is all about secrecy, and so it has to be information of commercial value. It has to be kept secret by the business, not known by competitors, and it can be a number of things. We think about designs, processes, compositions, things like that, but it can also be customer lists, marketing information, production devices. Basically, in order to be potentially protected by trade secrecy protection, it basically just has to be held in confidence by the company or by the entity, rather. Ideas can be trade secret, but only if generally unknown. They don't actually have to be completely unknown, as long as they're not widely known. The term of trade secret can be indefinite. This is why Coca-Cola has never patented the Coca-Cola recipe, because Coca-Cola, the recipe for the syrup is a closely held secret. The criteria that are applied or the techniques that are applied by Coca-Cola to keep it a secret are extensive. And so by virtue of doing that, if they had patented it, the patent would have expired by now, and anybody could make Coca-Cola. But by keeping it a secret, then certain legal protections arise with regards to that secret. The conditions must be subject to reasonable, diligent measures to guard the secrecy of the information. And there's a list of those here. I'm not going to read them to you, but basically it's making sure that people who don't have access or don't need access to the information don't have access to the information. And those who do have access to the information are made aware or bound to prevent them from disclosing it. Now, one of the things about trade secrecy is that, one, it's mutually exclusive with patents, because patents publish, and by virtue of the publication, it would no longer be a secret. The subject material would no longer be a secret. Also, although there is relief under trade secrecy laws with regards to the misappropriation of a trade secret, that relief is typically against the party or entity that misappropriated the information. The trade secrecy itself may nevertheless be destroyed, right? So say that, somebody got a hold of the Coca-Cola recipe and they broke into Coca-Cola's headquarters or whatever, and they disseminated that information, then Coca-Cola would have recourse against that person or that entity, but the trade secrecy itself would be destroyed because it was no longer a secret. Again, there's potential monetary damages based on that loss, and potential punitive damages and criminal prosecution. Let's see here. Reverse engineering is all right under the laws of trade secrecy, as long as there isn't some sort of license agreement prohibiting that reverse engineering. But if I get a bottle of Coca-Cola and I sit down with a mass spectrometer and I figure out what's actually in it, then that is actually okay. Non-disclosure agreements. Non-disclosure agreements prohibit disclosure. They are dispositive, or they are evidentiary, rather, as to whether or not trade secrecy conditions have been enforced. They are evidentiary as to whether or not public disclosure has taken place with respect to a patent. But they're not dispositive, right? So if somebody signs a non-disclosure agreement and they violate that anyway, then that violation if it's a disclosure for the purposes of patentability, may still prohibit patentability based on public use, offer for sale, or printed publication, notwithstanding the NDA. Similarly, if somebody signs an NDA and they disclose information that was subject to trade secrecy protection, then they may have violated the NDA, as well as maybe in trouble under trade secrecy laws, but the trade secret itself may still be destroyed, notwithstanding the NDA. Non-competes are increasingly being disfavored at law. In Indiana, an employer must have a legitimate interest to be protected. An agreement must be reasonable in scope as to durations, geography, and activity. They cannot completely close off an employee's ability to make a living. And as I recall, there's been some recent case development or some recent legislation having to do with non-competes. And essentially, they're becoming highly disfavored. We don't really like to prevent people from being able to make a living. So that is patents, trademarks, copyrights, trade secrecy, and non-disclosure agreements. Trade dress is another form of intellectual property. I'm not really going to get into that one too much. It basically has to do with, you know, for example, a store that has a certain way of decorating the store, or a vehicle manufacturer that has a certain way that all their vehicles have common design cues. Those can be trade dress. There's a certain amount of enforceability with respect to those. But essentially, that is patents, trademarks, copyrights, trade secrecy, and non-disclosure agreements in an hour and 15 minutes. Does anybody have any questions?
You know, there was one question brought up a couple of times about the difference between patenting with an attorney versus pro se.
Well, I can tell you this. I needed to get a will made. I'm an attorney. I went to an attorney that dealt with wills because he had expertise that I don't have. Right? Yes, we talked about wills and estates and things like that in law school, but I haven't practiced that. And so I'm not up on all the latest and greatest. I have a lot of people that come into my office with things that they've attempted to do themselves. And sometimes we can save it and sometimes we can't. Be particularly careful with respect to certain legal services that are available for low cost. Be careful of the LegalZooms of the world. Be careful of the InventHelps of the world. I'm not going to directly criticize them, but there's certain reasons why those services are inexpensive. I've been doing this for 20 years. There's ways to do it right and there's ways to do it wrong. There are ways that will get you through to perhaps even issuance so that you have a patent or trademark or whatever in your hand, but actually you're going to have a hard time enforcing that. And so there's a lot of, one of the things I neglected to talk about along the way, which I should have, is, you know, with respect to patents, you have at most a year following a public disclosure, offer for sale, printed publication of the invention, if it and subsequent to somebody else's filing. If somebody else files a patent application that covers the same thing, there is no grace period. Patentability is dead at that point. Understanding how these rules work with regards to patentability and obtaining a valuable patent right takes a lot of experience. And so they say that pro se, people that proceed pro se, whether it's under patents or whether it's for any other legal service, has a fool for a client. And there's good reason for that. Again, these are very complicated areas. There's a lot of nuances involved, and there's a lot of ways, there's a lot of traps to fall into. So, you know, yes, there's always the right in US law to represent yourself. That's a constitutional right, basically. But it's also not a very wise thing to do. Other questions?
Enter it in chat if you, something you want Gerald to address.
Well, everybody's thinking another time that this comes up is, you know, particularly with provisional patent applications, there are a lot of services out there that will file a provisional patent application for not much money. The issue with a
There's
provisional,
one comment that says, as a patent examiner, I have awarded patents to proceed. So
sure,
your last slide has your contact information, Gerald?
it does.
All right, great.
Let's see here. Well, one of the slides does. Here we go.
Okay, good.
Yeah, I mean, you know, everybody has that right. I was going to talk a little bit about provisionals. You know, there's a lot of low-cost services for filing a provisional. What they tend to do is they have you write a couple of paragraphs. You file the provisional. In due course, you file your non-provisional. Only the material that was in the provisional or was enabled by the provisional is entitled to the filing date of the provisional. The examiner actually usually doesn't care. They really don't compare the provisional to the non-provisional, rarely. It isn't until that patent ultimately matures into a patent, and say that you're relying on that provisional filing date to overcome a bar to patentability, and the opposing counsel looks at the provisional and compares the provisional to non-provisional and says, oh, this provisional didn't have everything in that the non-provisional had in it, and so it's not entitled to the provisional filing date, so the ultimate patent is invalid, no good. So there's a lot of ways when we think about having a good, solid, enforceable patent, there's a lot of ways to do it wrong. Other questions?
Yes, I have one question about who calculates the loss.
That comes out at court. That comes out during discovery, right? During the discovery process, we make those determinations as to who made what based on sale of the product. So yeah, that's something that happens at litigation. Notably, I do not do litigation myself. I do want to point that out. I'm involved in acquisition, which we call prosecution, helping people get patents, trademarks, and whatnot. I'm involved in licensure and other forms of agreements. I'm involved in legal opinion work. You know, is it patentable? Is it registrable? Am I actually infringing this patent? Is the patent any good? That sort of thing. I do enforcement right up to cease and desist, or responding to a cease and desist, or negotiating prior to litigation. Once somebody files a complaint, I have never been inside a courtroom. It is my life's ambition to never enter a courtroom. I avoided it like the plague during law school, and I recommend to all my clients that they avoid the court like the plague. Because essentially most intellectual property is highly transactional anyway. You know, if you've got a patent that covers the better mousetrap, and you find out that Black & Decker is infringing that, you actually don't want them to quit. You just want your cut, right? I mean, Black & Deckers can have market share for mousetraps that you'll never get. And so most of the time when everybody's rational and when people play relatively nice, considering the circumstances, most of the time we're able to assign a value to that, shake hands, you know, exchange some funds, and, you know, some licensure, and, you know, the world gets the better mousetrap. There are those that go straight to litigation. I tend to think that doesn't end well. Typically the most people that make any money in courtrooms are attorneys. And so unfortunately that's the way our society works. But for the most part, like I say, most intellectual property issues are resolved prior to or early on in litigation.
Well, we've taken up an hour and 20 minutes of your time, Gerald. I appreciate you presenting this for us again. And with that, we're going to let you go. So
All
a
right,
copy
very
of
good.
the presentation and the recording will be sent out to those who attended. So thanks so much.
Thank you. Everybody have a good day now.